Good morning and welcome to the Board of County Commissioners Land Use Meeting. Today is Thursday, August 28th. We do begin each of our meetings with an invocation, and this morning we have Susan Gillespie from the Road Church. We invite you to stand and join us.
Good morning. Shall we pray? Dearest God, we come before you today to give you thanks and praise you for this amazing day. May we be godly servants in all that we do, walking in your ways and bringing glory to your great name. Thank you for the opportunity to serve in our local government and for the freedom to do so. We ask for wisdom and discernment and a spirit of humility to carry out the duties you have blessed us with. Help us to have the mind of Christ as we serve the citizens of El Paso County, for we know that decisions we make have far-reaching and lasting effects, not only for us, but for our children and grandchildren and those of the Colorado men and women that we serve. May justice and righteousness reign in our community, our region, our state, and our country. May our government, local as well as national, set a standard that magnifies our God and all that he represents. We pray that our motives be pure and selfless, bringing honor to our God and Father as well as to our beautiful state of Colorado. Give us divine strength and endurance to make decisions when it's hard to see a clear path. Father, we ask for your blessing for the families represented here, for we recognize the sacrifices made by them. We pray they would have peace and support. We ask all things in the mighty name of our King Jesus. Amen.
And this is a bit unorthodox. I'm just going to take a moment and say, before we begin the pledge, I'd love to do just a moment of silence so we can maybe add some additional prayers to those for the families of those who were affected by the shooting at the Catholic school in Minnesota yesterday. So I'll just take a moment, and then when we have finished that moment of silence, Commissioner Wysong, if you'd like to lead us in the pledge. Item 3.
Item number 3 is staff emergency items, and I'm unaware of any staff emergency items today.
Item 4.
Item number 4 is changes, postponements, and notice of the next meeting. I'm unaware of any changes or postponements to today's agenda, and the next meeting will be Tuesday, September 2nd at 9:00 a.m.
Item 5.
Item number 5 is public comment on items not scheduled on the agenda. And Madam Chair, I'm unaware of anyone signing in to speak under public comment today.
Okay, is there anyone here today who'd like to speak on an item that is not on the agenda? Seeing none in the room and none online, we will move to item 6.
Item number 6 is the land use consent calendar, including items 6A through 6D.
Okay, is there anyone here who wishes to speak on an item on the consent calendar? Sir, please do come forward if you'd like to speak. We would ask you to sign in if you have not done so already. Okay, then you can just introduce yourself for the record, and you will have 3 minutes.
My name is Tim Flannery. I'm a resident of Falcon on Judge Orr Road. I was here about the Jane Davis Ranch. I'm here to say I'm not in opposition to it. I think it's actually a very good plan for that property because it matches our area, but 2.5 and 5 acre lots, that's what we have. I think my only concern that came is to try to find out their plan on what type.
Sir, I'm so sorry to interrupt you, but would you mind pulling that microphone up a bit because we're having a bit of trouble hearing you. Thank you. Please proceed.
Okay. I guess the reason I came in, I was just hoping to get some clarification on the types of homes that will be put on the lots, if there's going to be any covenants about animals on there for agricultural use, And I was a little concerned about seeing some commercial lots in there as well. And that was only the reason it came. I just wanted to find out if there was any clarification on those.
So I think probably our best way to proceed on this, so this is a sketch plan, and we may not have the level of detail that you're looking for, but I would like to connect you with our planning department. They can kind of help explain the process, because there are additional processes through this that they can make sure that you are connected. Megan, can you help this individual? That would be great. So thank you so
Thank you.
much for being here, and we'll make sure you get connected. Okay, is there anyone else who would like to speak on an item on the consent calendar? All right, I see none in the room and none online, so I will bring it up here for additional comments or a motion.
I would move approval of the consent calendar.
Second. Oh,
We'll let our clerk decide who won. So that has been moved and seconded, and I will call the roll. Commissioner Wysong.
aye.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams.
Aye.
And the chair votes aye. That passes 5-0. Item 7.
Item number 7 is the called up consent calendar, and there are no items called up today.
Item 8.
Item number 8 is the waiver for Mariah Trail waiver, a request by Wayne Anthony Custom Homes for approval of a waiver of Section 851C of the El Paso County Land Development Code. Section 851C requires land being dedicated to the county to be free and clear of encumbrances. The property is located at 19205 Mariah Trail and is located 0.20 miles south of the intersection of Mariah Trail and Thunder Road West. This item was heard by the Planning Commission on August 21st, 2025, and was recommended for approval by the Board of County Commissioners with a vote of 4-1. I think correction to that, it should be the Planning Commission. Parcel number 51000000511, Commissioner District 1, file WV 25001, Kylie Bagley, Principal Planner, Planning and Community Development.
Good morning, and
Good
please
morning.
proceed with your presentation.
Good morning, Commissioners. I'm Kylie Bagley. I was the planner assigned to this project. It's file number WV251 for the Mariah Trail waiver. Daniel Torres was the engineer on the project as well. If there's anyone who has public input and is watching remotely, please email your information and phone number to pcdhearings@elpasoco.com. And then this is just kind of an overview of our hearing procedure today. I'll go ahead and skip through this. And then in front of you is the criteria of approval for the waiver from section 7.2.1 in the Land Development Code. I'll let you go ahead and read that, and you can let me know when to move on. Perfect. So the request in front of you today is for a waiver of section 8.5.1C of the El Paso County Land Development Code. This section of code states that all dedicated land shall be free of encumbrances. And you can see right here on the slide, I did add that section of code for you to read. And then also the purpose of the waiver section is to be able to provide flexibility in the application of this code when a subdivision design standard is inapplicable or inappropriate to a specific subdivision design. So this section of code is within the subdivision design standard of the Land Development Code. So the waiver section does apply to this. So this item was heard by the Planning Commission on August 21st, and it was recommended for approval with a vote of 4-1. Mr. Kirk is the property owner. On his property is a 16-foot wide access easement that Ms. Donahue and DKSS are easement holders. Mr. Kirk did apply and get approved for a subdivision last year that would subdivide his 35-acre property into 6 residential lots. As part of that final plat approval, Mariah Trail, which you can see on the screen here, is to be extended into Mr. Kirk's property to provide future public right-of-way. So within that future public right-of-way, part of that 16-foot access easement does lie within that road. So Mr. Kirk has tried to get Ms. Donahue and DKSS to vacate that portion of the easement that would be in the road. It's roughly 350 square feet. Unfortunately, he could not obtain those signatures to get that vacated, which is why he is asking for the waiver. So this is just some history on the property. It's kind of hard to tell, but this is the extension of Mariah Trail Road. And then there's a tiny portion of this 16-foot access easement that does, that will be within that public right-of-way. So Mr. Kirk has worked with the property owner to the north, or tried to work with the property owner to the north to purchase land to move the county right-of-way out of that 16-foot wide access easement, but was unable to obtain land from that property owner. He has been working with staff to try to go through alternatives, and unfortunately, this is where we've ended up. So this is a better, yes.
Yeah, you may answer it here on this better slide. So I have a question. The waiver is the little skinny easement.
Yes.
And will this new thing be a road that connects into the waiver? The Tract B, where it says Tract B, it looks like it's a road.
So Tract B will be reserved for future public right-of-way. So if Ms. Donahue or a future buyer of her property were to choose to subdivide, they could purchase Tract B to make into a public road to access this land.
Okay, thank you.
And then same, there's a tract here you can't see, but Tract C will also be reserved for future public right-of-way, so they will have connectivity to the east and the south. But on this screen, you can kind of see the yellow highlight. That's where that access easement will be within the public right-of-way. So that's the only portion that we're asking for the waiver, not within the full access easement. So it is approximately 350 square feet. So some implications if the waiver were to be approved is that if the waiver is approved and the county does accept the right-of-way, it would have an underlying access easement. The rights of the easement holder are superior to those of the county, and in the event of a conflict, the easement holder would likely prevail. And then the applicant is here to speak on the project if you wish to have him come down, or I'm happy to answer questions about this.
Are there any questions for staff? Okay, so we'd be happy to hear from the applicant.
Good morning, Commissioners. My name is James Tilton. I'm here on behalf of Wayne Anthony Custom Homes, who submitted this application and the subdivision application for Mr. Kirk. They're a land developer who's working with Mr. Kirk and previously went through the prior application, which was approved to subdivide Mr. Kirk's property into 6 lots. Also, again, just to be clear for the record, I do not represent Mr. Kirk. I represent Wayne Anthony Custom Homes. And thank you, Kylie, for that very thorough overview of this matter today. So again, here's another map of the property. The blue line you see here is Mariah Trail, which is a public road. It's free to access for all public. That blue star is Mr. Kirk's property, which is the matter of the topic today. Here's another map, again showing Mr. Kirk's property and then the neighboring properties that are impacted by the proposed subdivision that, again, has already been approved by El Paso County. There's our Vina Donahue's property directly to the east. Further east of that is DKSS's property. And there's also Mr. Colt Hagen's property to the south. Also, Mr. Colt Hagen is one of the partner owners of DKSS, and I believe he is here. Yes, he is here today as well. As Kylie already explained to you, the land subject to this waiver is 350 square feet of the right-of-way. It's not the entire right-of-way that exists across Mr. Kirk's property. The existing right-of-way for Ms. Donahue's property and DKSS's property will remain in place. And except for these 350 square feet will be unaffected by this waiver should you choose to grant it today. Because the rest of the easement will still be over Mr. Kirk's property, which will not be affected by the Mariah Trail extension that's planned. Again, Mariah Trail is a public right-of-way. That extension will be a public right-of-way. Anyone can access it, including these neighboring property owners. This waiver will not have any effect on impeding Ms. Donahue or the owners of DKSS to access their properties. We've had extensive discussions with staff with El Paso County, and they've assured us that there's no issue with these private right-of-ways abutting Mariah Trail, as will be the case. As was pointed out last week, of that 350 square feet, only about 150 square feet of it will actually be roadway. The other 200 roughly square feet is going to be additional land around it, but still does fit within the amount that we're asking for the waiver. As far as benefits to the parties, it's going to reduce the length of the driveway, which will be less maintenance for Ms. Donahue and Mr. Kirk to have to worry about. Also, the real huge benefit to all neighboring parties is that this planned subdivision is going to guarantee future access. It will ensure future access because of the designated tract B that was pointed out by Ms. Bagley to Ms. Donahue's property. As it is now, Ms. Donahue's property is landlocked. If she wanted to develop her property and she was here before the commission, she would have to go to Mr. Kirk to get an easement because the easement she has would not be sufficient for development. What we're doing with this proposed subdivision is we're guaranteeing future development is possible for both Ms. Donahue's property and Mr. Colt Hagen's property to the south. I also wanted to emphasize that these easements that the neighboring property owners have are only for access to their lots. It doesn't give them complete unfair control or access over this land. It is still Mr. Kirk's land. This is Mr. Kirk's property we're talking about, not Ms. Donahue's, not DKSS's. The last thing I'll say on that note, as far as this being Mr. Kirk's land, is just for instance, if Ms. Donahue or DKSS wanted to plant trees or shrubs along the driveway, they would not be able to do so because this is Mr. Kirk's land. They can't add or expand that driveway beyond the scope of what's been granted to them. They can't add a turnaround for ease of access. Those would all be outside the scope. The easements that are in place are very limited. The waiver request, as Ms. Bagley identified, is for El Paso County Code Section 8.5.1, which applies to public land dedications. The dedication of Mr. Kirk's property for Mariah Trail is for the public benefit, is a dedication of his land for the public. We're just asking for the waiver because El Paso County has the requirement that that dedication not be encumbered, and technically these easements in place are encumbrances. The factors you have to consider, Ms. Bagley had up here earlier, I have them up here again. Going over them briefly, Mr. Kirk's land development isn't going to impact or nullify anything with El Paso County Code. It's actually already been approved. It was approved last December. It only came up after approval that these signatures were both required, and we've been trying to work out through negotiations and other means with the county, and this is where we find ourselves now before you asking for this waiver. It's not anticipated there'd be any need for future waivers. This is the end of Mariah Trail. It's a dead end against Mr. Kirk's property. We're simply extending that, and then again, ensuring future access to both neighboring properties with the Tract B and Tract C that have been built in to the proposed subdivision map. There's no public harm. There's no harm to the neighbors. There's no foreseeable injury. This situation is unique because of the parties involved in the properties. Ms. Donahue and Mr. Kirk used to be married. They divorced a few years ago. And this property was at 1.75 acres. They split it between the two of them in their divorce, and each are trying to enjoy and use the land as that they got in their divorce as they see fit. That at this time is Mr. Kirk wanting to build a home for himself to retire in, and also to subdivide his land. Strict application of this code would cause a hardship. Obviously, there's a financial hardship to Mr. Kirk, but there's also the non-economical hardship, which is part of your decision today. Mr. Kirk is the property owner. He has the right to use his land as he sees fit, and he has the right to enjoy the land as he wishes. If this waiver were not to be granted, that would impede his ability and rights to use and enjoy his land. It also would leave him in a situation where potentially having to go back to court with Ms. Donahue, which I'm certain would be very emotionally tolling for both parties and stressful. Granting this waiver would avoid that situation for both parties. This waiver isn't going to affect any zoning provisions. This land has always been zoned RR5. That didn't change. Mr. Kirk didn't have to ask to change the zoning when he subdivided this land. It has always been that way. It was that way when Mr. Kirk and Ms. Donahue previously acquired it when they were married, I believe in 2013. And providing this waiver is not contrary to the code. Again, relating back to the fact it's always been zoned RR5, it's always been contemplated in the master plan that this land would be developed as we've requested and has already been granted. Mr. Kirk has been very flexible with his neighbors and with the county. He's dedicated very large portions of his land to ensure future access for the neighbors and other additional neighbors that will come when the property is developed. Again, both properties are currently landlocked, even though they also are zoned RR5. And then I have more details here, specifically Tract B, which goes to both Ms. Donahue's property and then would be foreseeably extended over her property when that were developed to DKSS's land. That totals roughly 37,518 square feet of his land, which he will not be able to develop. He will not be able to do anything with it. It's basically now going to be reserved for this future development of the neighboring lots. He's also dedicated 78,120 square feet for Tract C, which will go north-south to the southport end of his property against Mr. Colt Hagen's property for its future development. That's how much square feet, roughly, he's agreed to designate for these developments, and we're asking for a waiver of 350. That's it. This is the plat map pending approval. Again, it's kind of hard to see here, but I've highlighted that small portion where the easements will overlap Mariah Trail. This map does show better that Tract B running east-west and Tract C running from north and then curving down to the south. So we're requesting this waiver today so that Mr. Kirk can move forward with the subdivisions already been approved and to use his property as it's always been zoned and as he wishes as a property owner. This land hasn't historically been used as open space. It's not used for recreation. It's always been used for residential, and that will continue to be the case. It's just going to be in smaller portions of land. That being said, it's also still going to be 5-acre parcels. We're not doing 2.5s. We're not doing anything outside the scope of how this was already zoned. Granting the waiver is not going to affect Ms. Donahue's ability to access her property or DKS's ability to access across their easement, which also does go over Ms. Donahue's property. Their access will remain the same, other than this 350 square feet that will overlap with Mariah Trail, which also will have to be improved. It will actually improve that portion of the land, which will have to be up to the county's code, whereas the existing access over a driveway is not up to a specific standard or code. Again, it will increase the means of access to those neighboring properties. It won't unreasonably inconvenience any of the neighboring properties, and it won't injure anybody. The other matter, which was raised last week, which I'll touch on briefly, is a question as far as what happens after this in the future. Because yes, foreseeably for now, there will be this overlap of Mariah Trail over the access easement. What I would pose is the county, if or when Ms. Donahue's property is developed, whether it's by her or a future property owner, could at that time require, or likely would require, a vacation of that easement, at which point it would go away and now all you have is Mariah Trail. That's it. At that point, there would no longer be an easement in conflict with the county's Mariah Trail tract on Mr. Kirk's property. I'm happy to address any questions, and I know Mr. Kirk is here to address any questions, as well as my client, Wayne Anthony Custom Homes owner, Mr. Darren Straub, is here to answer questions if I can.
Okay, are there any questions from commissioners at this point for the applicant? Commissioner Wysong.
So Mariah Trail will be extended into Mr. Kirk's property, and then would Mariah Trail then extend across his property in Track B to, the next section of property? Or does Mariah Trail as a county road stop at Mr. Kirk's property? I'm a little confused, and especially that last part of your statement you had made just a couple of minutes ago.
Certainly. So should the waiver be granted immediately, Mariah Trail will be extended onto Mr. Kirk's property. If I go back, maybe I don't know how to. Okay. This map's best. So that roundabout will be formed. That will now be the new end to Mariah Trail. It will come onto Mr. Kirk's property, kind of like a teardrop and roundabout there. There will be private access ways off of that, which will be driveways to lots 1 and 6. Lot 6 driveway will be the existing driveway as it abuts Mariah Trail. And then there will be a private road added along Track C for access to lots 2, 3, 4, and 5. And that will be the end of Mariah Trail for now. In the future, when Ms. Donahue or some other future developer goes to develop that property to the east, at that point, according to HOA documents that we will record with the county, Tract B will be developed, which presumably if that happens first, I assume that will be an extension of Mariah Trail. So that will become the new Mariah Trail across Mr. Kirk's property will be added onto, or it could be a new road. I don't know what it would be called, but that road would be added onto Mariah Trail for access and then dedicated to the county as a public right-of-way. And the same for Track C.
Okay, thank you.
Vice Chair Williams.
Staying on this map, so the only part of the easement that is a part of this waiver is that highlighted in yellow, whereas Lot 6 will still have the easement going across it. Am I correct?
You are correct.
Okay, thank you.
And I'll just ask one question for clarity, but I think I know the answer to this. When we're talking about that Tract B, we're talking about how that road will currently terminate on this property, and then Tract B is reserved for future development. If that development never were to take place, obviously, that is not a requirement moving forward. It's just reserved in the for the opportunity if one of those other property owners does decide to develop.
Yes, exactly. And that's true for both Tract B and Tract C. Both of those were included in the proposed plat map with negotiations and discussions with the county. Like I said earlier, because these neighboring properties are landlocked, these reserved tracts, which because they're reserved will not be developable by any of the overlying property owners, guarantee sufficient future public access for those neighboring properties that are also zoned RR5 if or when they're developed. If Ms. Donahue's property remains a 40 acre tract with just one house and some horses on it, that's fine. Then the existing easement will remain in place and Tract B will never be developed, but it will be there reserved should that change.
Thank you. Okay, any additional questions? Yes, Commissioner Nelson.
So am I to understand that currently that Mariah Trail Road ends at the property line
Yes.
and then that cul-de-sac will be developed upon approval of all of this? Who's responsible for the costs of that? If it's continuing a county road, is the county responsible for the costs of paving that cul-de-sac or building out the cul-de-sac, or is that the property owner?
And I welcome Darren to correct me if I'm wrong, but if I understand correctly, Wayne Anthony Custom Homes will be responsible for building and constructing the cul-de-sac extension of Mariah Trail, which will then be dedicated to the county, and thereafter the county will at that point be responsible for future maintenance. My understanding and recollection is Mariah Trail is not a paved road. I think it's like a hard packed.
Daniel Torres with the Department of Public Works. As Tilton indicated, Mariah Trail will be constructed by the developer. They will have the burden of cost of constructing that to our standards. Upon acceptance, that will go into our transportation network for maintenance. Indicated.
All right, thank
And
you.
it currently is a gravel roadway.
Okay, thank you. In the packet, there in the 81-page packet, there are pictures of a truck on the property. What was that supposed to convey to us? And it said there were no trespassing signs in the driveway. Was that just to kind of show the disagreements between the property owners, or why was that information included?
So I can't answer exactly why that was included. I did not submit those photos. Those were submitted, I believe, by Ms. Donahue and her counsel, Ms. Fortenberry. I guess what I will say on that is I know I saw the photos last week. They showed, and I assume these are the same photos you're looking at, obstructions that have been put in place, I believe, by Mr. Kirk. Those, as I understand it, have been removed and were removed a couple of weeks ago now and remain not there.
Okay, so it's not really relevant to our decision today.
I don't believe it is. Those obstructions that were put in place were at the border of Ms. Donahue's property and Mr. Kirk's, which is on the opposite end of the property from the 350 square feet where we're asking for this waiver.
Okay, thank you.
Okay, one more ask. Are there any additional questions for the applicant? Okay, thank you.
Thank you very much.
Did we have any additional, I'm sorry, any additional input from staff at this point?
No, I was just going to answer Commissioner Nelson's question, but I think the applicant did a good job.
Great, thank you. Okay, at this time, we will move to the public input portion of this hearing, and we will begin with anyone in support of this application. If you are here to speak in support of this application, if you would come forward at this time. While you're coming down, I'll just remind you if you can please sign in and then make sure you clearly state your name for the record, and you will have 3 minutes. And since I can see that you are tall, I'll ask you to straighten that microphone up so that we can hear you.
Don't forget dark and handsome. Thank you. Good morning, everybody. How are you today? My name is Colt Haugen. I am a partner in DKSS and a co-manager of that entity. I also own all the property to the south. I also am a trustee of a living trust of our other property, which is 40 acres that also to the south of mine. So all total, we have about 200 acres that abut this subdivision. And I am in support of this. I know that's a shock, right? You're looking at it like, why would he do that? The deal is I have worked extensively with Ms. Donahue, Mr. Kirk, Wayne Anthony Custom Homes, and the applicant has been nothing but gracious and kind and easy to work with. I'm a pretty good negotiator, and that track C that goes down was at my behest, right? That's my access point. I'm going to use it as a driveway. They've agreed to everything with that for me. My access isn't changing from DKSS. It's not going away. It's not being moved. It's being improved on the last tiny little piece. I've had it surveyed. We've walked it. We've talked it. We've done everything there is to do here. And there is just no other path forward here but to approve this waiver. I'm happy to answer any questions that you have for me. There are exceptions to rules, and this is an exception to the rule that needs to be approved. Any questions? Anything I can ask for you?
I don't think so at this time. Thank you
guys
so
very
much.
Appreciate your time.
Okay, is there anyone else who would like to speak in support? Make sure we have no one online, thank you. And so with that, we will move to anyone opposed. Is there anyone here who'd like to speak in opposition to this application today? And again, same rules apply. Please do sign in, speak clearly into the microphone so we can get your name for the record, and you will have 3 minutes.
Good morning. A little nervous, so I apologize. My name is Arvina Donahue. I live at 19275 Mariah Trail. I appreciate the opportunity to speak today. I will begin by stating that I'm not against the proposed Mariah Trail filing development. I am deeply concerned about my rights as a property owner and how a proposed waiver of my recorded driveway easement by this Board of County Commissioners that provides egress to my home will look if the waiver is indeed approved. As Mr. Tilton, counsel for the Wayne Anthony Custom Homes, has already put on record, I'm the ex-wife. As such, I currently continue to carry the mortgage for the 75 acres, 35 of which are being discussed here today in the proposed subdivision. I also take care of all aspects required for the daily care and upkeep of the 5 horses that were abandoned by Tom Kirk. There are basically 4 parties involved in this business transaction: Tom Kirk, landowner, Wayne Anthony Custom Homes, developer, Colt Hagen, who you just heard from, landowner and developer, and myself. The first 3 parties all stand to make significant financial gains from this transaction. On the other hand, myself, a landowner who has now spent several $1,000s protecting my access to my home. Originally, Colt and I were in the same position. We were first asked to vacate our entire easement for the subdivision. It was more distance than the approximate amount of 350 feet that's presented in front of you today. The original plat map had a public right-of-way on it, which is now called Track B. We both responded with a no in the beginning. Darren, the developer with Wayne Anthony Custom Homes, and Tom Kirk, the landowner, then went to Drew Soul, the neighbor who lives to the north of the cul-de-sac at 19510 Mariah Trail, to offer him $15,000 for approximately 400 feet of his land in order to bypass Colt and myself vacating the easement. Drew turned down the offer. Colt then negotiated the proposed road and/or driveway coming through the subdivision, along with utilities, be brought to his property line. This is approximately 1/4 mile of valuable compensation between developers, a road and utilities. I have asked for monetary compensation also and been refused each time. The attorney and surveyor that I have been forced to hire to protect my rights to access my own home have cost me several $1,000s. Drew was offered $15,000 for 400 feet. Colt is receiving a road and utilities that he will expand, tie into, etc., as needed for his future development of all the property that he just told you that he has. My attorney and I submitted a proposal on July the 15th of 2025. It was not accepted. I was told by text message that Tom and the team were coming to the county for a waiver, hence we're here today, to get around my having to vacate my easement, and poles would now be placed in front of my gate, which are the pictures that you referred to earlier. I returned home from work to find the driveway I have used for 12 years now blocked. I've had to cut my fence to access my property. Cameras were installed to harass and intimidate me as I entered and exited my property. Tom, with Darren's assistance, measured the area, and then Tom put up T-posts and barbed wire to form a narrow chute. The chute severely restricted my access.
Ma'am, I just want to make sure you saw that your time has expired, so if you can please wrap up your comments. And I would encourage you to remember that we must utilize the criteria, so if you can speak directly in that wrap up to which criteria you think is not met, that would be helpful for the board. Thank you.
The criteria that speaks directly to the harm and detriment that they are stating would not occur. It has already occurred. My driveway has been blocked. The biggest problem with this situation is not about the 350 feet. The easement to my property is not agreed upon between the parties. So as Mr. Tilton put on record at the hearing last week, the developer and myself and Tom Kirk do not agree to what my easement is. That is the problem. If you approve this waiver, where does it leave me? The easement has not been properly reviewed and agreed upon between the parties. I want to be able to still have public access or my private access to my property. That is where the harm would come.
Thank you. Thank you for your time today.
Thank you. I appreciate you allowing me to speak.
Okay. At this time, do we have anyone else who'd like to speak in opposition?
Thank you, and good morning. I'm the attorney for Ms. Donahue. I'm hoping that I could have a few additional minutes to speak to you from the legal perspectives. Is that allowed?
I think we can go ahead and set the clock for 3 minutes as we would for anyone, and we'll work from there if you still need additional time to wrap up.
Thank you so much. A couple of things that were represented to the commissioners. This is not a landlocked parcel. Ms. Donahue has a granted and recorded easement. It's recorded at reception number 221099747. That is not reflected on the plat, which is of concern to us. The easement that's reflected on the plat is Mr. Haugen's easement with a different reception number that dates back to 2013. So if commissioners are inclined to approve the waiver, we think it's important that the plat be corrected to reflect the fact that Mr. Kirk granted Ms. Donahue a specific easement and that reception number is reflected on the plat, along with the assurance that was granted in the easement, and I submitted this in your packet, that the purpose of Ms. Donahue's easement is for her to have open and clear access via the existing driveway. So the point being, Commissioner Nelson, of why we submitted those photographs is because the parties didn't come to agreement, and out of frustration, Mr. Kirk actually shut off her easement. And so he put those poles in it so she couldn't access it. That's been her access for decades, and that easement has been in place for many decades. So that driveway, pardon me. So I think it's important that, number one, it be clear in the plat notes that this public dedication is subject to this existing recorded easement, driveway easement. So that people buying in the subdivision understand that there's this easement in place and they can't occupy it, that the Tract B that is proposed can't be shut off, it can't be gated, because the commitment with the superior easement of Ms. Donahue is that it's open and clear access. So no gates, no obstruction during construction, that open and clear access has to be protected. And we don't see any protections in the proposal or in the plat notes providing the kind of protection that Ms. Donahue is requesting and needs to be able to traverse her sole access to her property. In terms of the standards, I'll speak to those just very briefly. The waiver, the purpose of the waiver, as discussed in the Land Development Code, is to seek relief from design standards. This is not seeking relief from design standards. This is seeking relief from the mandatory dedication requirement that be free of encumbrances. So we don't think it really meets the purpose of the waiver, although staff disagrees with that position. Second, the only demonstrable harm that Mr. Kirk can speak to is economic harm. My client has asked for compensation. It's typical, as my understanding is, that in this country, when you are asked to give up a property right, you're compensated for it. And so I think this is a matter of private negotiation, as my client said. I thank you so much for your time and attention.
Thank you. Is there anyone else who'd like to speak in opposition to this application? Okay, I see no one online and no one in the room, so we will close that portion of the hearing. And we will bring forward the applicant if they'd like to do any rebuttal.
Just,
And who's your question for?
I'm
Sonia?
sorry, just one question for Ms. Donahue's attorney.
Okay.
I have one question
If you'd like
for
to
you.
come back up, so we do have a question for you. Yes.
Yes.
The attorney, yes, ma'am.
Could you tell me, number one, what is the address of Ms. Donahue's property? 19275 Mariah Trail? Okay. And what was your proposal for the value of that amount of the orange area, the little yellow area?
For purposes
Is
of
your
compensation.
proposal for compensation to make sure you have access to the easement, or is it for that little orange, little yellow section on the map?
So the compensation was for the vacation of that portion of the easement, which was requested for purposes of the plating. I'm hoping I'm answering your question.
It does, thank you.
Thank you. And I'll add for my colleague as a reminder that it's actually that the property that was highlighted is owned by Mr. Kirk, the property owner. It's just the easement, right? So, okay.
Okay,
Thank you
correct.
very
Thank
much.
you.
We'll bring up the applicant for rebuttal now.
Thank you, James Tilton, again on behalf of Wade Anthony Custom Homes, and I'll be brief in my response. Also, my client Darren is here. He also would like to address with some comments when I'm done. First off, I want to address a few things that Ms. Donahue said. She said she's not opposed to the extension of Mariah Trail. My understanding and recollection is that she was opposed when this application first came through the county. I just want to make that clear that from our understanding, she's always been in opposition to Mr. Kirk's development, which necessitates the extension of Mariah Trail. Frankly, Ms. Donahue's statement that, or alluding to the fact that she doesn't stand to gain anything is just wrong. Again, as I've gone over repeatedly today, Mr. Kirk is dedicating Tract B for the benefit of her land. It will make her land more appealing to any future developer, whether that be a family that wants to buy her property with the thought of maybe developing it, or a land developer like my client who may see it as a property that can be developed into future 5-acre lots. The notion that Ms. Donahue isn't gaining any benefit or is getting less of a benefit than the other neighbors is just not there. It's not the case. There have been much more discussions, because they've gone well, with Mr. Cole Hagen, who the county heard from today. And due to negotiations going well, yes, he is going to immediately get more of a benefit than Ms. Donahue. But Mr. Colt Hagen came to the table and he didn't ask for what we interpreted as a inappropriate amount of compensation. I'm not going to go into the specific numbers because I don't think that's appropriate for me to do as counsel. As an attorney, we have ethical rules, and like Ms. Fortenberry, I'm not going to go into those specifics. But I would highlight what Ms. Donahue pointed out is, yes, at one point we did try, or my client tried, I wasn't involved at that time, to purchase a portion of land, a sliver, from a neighboring property owner to the north of Mr. Kirk. My understanding is he was offered 10 times the estimated value of that land, which he turned down because he didn't want to get involved what he saw as a personal matter between ex-spouses, and he's not wrong. That being said, I just point that out to say that that's what my client and Mr. Kirk were willing to do to avoid this sort of situation. What has been requested by Ms. Donahue is in excess of that. When I used the term landlocked earlier, I'm talking about for purposes of development. Yes, there are easements. Yes, that easement does allow Ms. Donahue to access her lot. DKSS has a 16-foot easement across Mr. Kirk's land and Ms. Donahue's land to access that lot. But those purposes are limited. They are not the necessary access to county code and standards that would allow a 8 or 10 family homes to be developed on that property. They are for one family at most. That's it. Again, as Ms. Donahue said, her driveway was blocked for a period of time. Admittedly, I'm not sure exactly how long. Again, Mr. Kirk did that, and he's not my client, and I can't speak to that. But those were removed at the request of Ms. Donahue, and again, have not been put back in place as a showing of good faith. I'm not going to go into all the details, but yes, there is ongoing discussions and disagreement about the easement. And I do touch on that because the map that Ms. Fortenberry referenced that I used in the slides, I believe this one. This is a map which I used, frankly, because it was the easiest map of this property for me to label with the property owners and it'd still be clear. This map was recorded in 2013 to memorialize DKSS's easement. Now, admittedly, I have changed this map. There's some highlights on it, and there's the name of the property owners. Those were not in the recorded easement map. This land survey plot that was submitted with that easement was also recorded with Ms. Arvina Donahue's and Mr. Kirk's property easement that Mr. Kirk granted to Ms. Donahue in their divorce proceedings. That's why it has a date of March 8th, 2021, when it was recorded. This is part of the reason that the parties disagree as far as the exact specifics of Ms. Donahue's easement to her property. What is not in contest is the fact that she has access to her property. No one disagrees with that. She clearly does have access. Furthermore, again, what we're here for today is a waiver of 350 square feet. That's it. The parties are likely going to have to continue to negotiate and sort out the matter of Ms. Donahue's easement, but that is not for this commission to decide or the subject of the waiver request. If you have any further questions, I'd be happy to address them. Otherwise, I'll turn it over to my client for a couple comments he wished to make.
Good morning, Commissioners. I appreciate your time and patience this morning. I do want to speak to a couple of the matters.
If you
on
could
here.
just state your name for the record so that we
Sorry.
have that.
Darren Straub with Wayne Anthony Custom Homes.
Thank you.
Couple of points I'd like to talk about. We did actually talk to the neighbor about trying to shift the road. We did actually offer him about 10 times what the value of that property was by market value. That sliver that we would need to shift that road to avoid the edge of the easement is probably about 3 times the amount of actual space is what this easement we're talking about is. And in that case, we were actually talking about purchasing land, not purchasing an access over that land for ingress and egress. Okay, so there's a big difference there. There has been offers to Ms. Donahue to clear up. We did find out that there was an issue with the access easement that she filed. She had prepared an easement during her divorce from Tom Kirk and had filed it, and there is an error with it, I guess is the best way to describe it. It actually follows the path that you see up there on that map. It changes course about 60 feet before it crosses her property line. Now, Tom has to make sure that not only her, but DKSS maintains access. That's legal rights. So we did actually have our surveyor stake the driveway because we needed to ensure that as we drop road base material and other stuff for this project, that we do not block the rights. So that's the whole intent. We don't want to block anybody's rights. We don't want to start any problems with anybody. In doing so, that's when it came to light that the easement that she had actually prepared and had actually filed did not follow what she was following. So then we're kind of torn. Do we mark out a path that's technically trespassing across Tom's property, or do we ensure that her legal path is accessible? Well, legally, we have to make sure that path is accessible. Now, Tom has, of course, allowed the other path across his property as well in a gesture of good faith. So unfortunately, we've just come down to a piece where we've tried to go back and forth, and we've tried to talk to all parties involved. We've met with Colt extensively, and he's been great to work with and tough negotiator, but good in talking to him and understanding the needs of DKSS that is landlocked and our Vinus property. We talk about landlocked, it's not an access easement for our house. It's landlocked in the sense that that zone is RR5, just like Tom's property. It's intended by the county plan to have rural residential 5-acre lots. Those cannot be developed right now without that right-of-way that Tom's giving up. Okay, so he is giving up. She does have a, significant financial gain off of this. That 37,000 plus square feet that Tom's giving up on market value right now is around $60,000. So Tom is basically giving up $60,000 to allow her to use her property as it's intended. We've met with Colt. We've come to an agreement with Colt to the point where he and I actually met out there yesterday afternoon with the utilities to ensure the utilities extend for him. So we've tried to work with everybody. Unfortunately, we just could not come to anything within what I would consider in the realm of reason with Ms. Donahue. And so unfortunately, we're here today. I appreciate your time. If you have any other questions, I'll be more than happy to answer.
I just have one question.
Vice Chair Williams.
Either you or Mr. Tilton could answer this. Does the plat map, or on the plat, does it reflect that the easement on that is correct? Or is it correct on your documentation in the packet?
In the packet, what is on there is the legally recorded easement that Ms. Donahue recorded. She paid to prepare it, she recorded it. That's what we have to put on there. We have shown a willingness to change that to the point where we even offered to pay for her attorney to review it and to have our surveyor actually write the new easement up so that it does actually work probably the way that it probably should be, okay? Even on that, we can't get her to agree. So I'm not sure what else to do. I mean, when you offer to actually pay for that and take care of that for somebody and they still refuse, it just puts you in a tough position. But we have to put on there what's legally recorded. I can't tell you what somebody may or may not have intended, if that makes sense.
Okay, that was my question. Thank you.
Commissioner Nelson.
This may be a question for staff. I'm trying to filter out the relevant information. We are being asked to decide whether to grant a waiver when what got caught was due to there being encumbrances on the property. I don't feel like we've heard about that aspect of it. Can you speak a little bit to, am I misunderstanding that there's maybe a lien or something on the property and that's why this got caught up?
I think the encumbrance, I'm going to try and help here a bit. I think the encumbrance is the easement. Seeing staff nod. So the encumbrance itself is the easement, and normally we would not accept the right of way with an easement, and so that's the issue at hand here is the county itself willing to accept the right-of-way with that easement? So if you want to speak directly to that, I think that might be helpful.
Sure, and I'm happy to address your question, Ms. Nelson. Yes, this is all before the county now, and the waiver we're asking for is regarding, again, that 350 square feet, because that 350 square feet, which was calculated by the county, as far as that specific number, is the amount of land that will be encumbered also by the existing easements. Both DKSS's easement, as well as Ms. Donahue's easement, because those easements have already been recorded with the county to guarantee access to those neighboring lots.
Thank you. There was just a comment made at one point about property ownership of 75 acres. And I think I just would like to have it clear for the record that Mr. Kirk is the sole owner of this property,
Yes.
just for the record to make that clear again.
Yeah, the 35-acre parcel that is pictured on Mariah Trail filing number 1, this in front of you now, that is Mr. Kirk's land, the entirety. That is all Mr. Kirk's land. DKSS does not own any of that land. Ms. Donahue does not own any of that land. What they do have is a easement for access to their adjacent parcels. That's it. But as Ms. Geithner identified, did I pronounce that right? Thank you. As Ms. Geithner identified in her response, Ms. Nelson, the easements being there over the land is what triggered this snag with the county approving this map, and thus our repeated attempts and negotiations, and then ultimately after multiple discussions with the county as well as legal counsel for El Paso County, our submission of the request for this waiver.
And so the easement, the waiver itself is strictly on the property owner's land.
Yes, for 350
Yep.
square feet, so that the county can, so that my client can build the extension Mariah Trail, which will then be dedicated to the county with those easements still in place.
Okay. The easement or waiver does not actually impact the neighboring property.
I would
It's
agree with
not
that
on their
statement.
land.
No,
Okay.
not at all.
All right, thank you. There's just a lot here that I'm
Yes.
trying to filter. So I appreciate that clarification. Thank you.
Okay, so I don't want to shortchange any of the commissioners if they have additional questions for the applicant, but we can also bring up staff to answer some of these questions from staff perspective as well. So I just want to make sure that everyone is aware of that. So at this time, I'll just ask commissioners, do we have any additional questions for the applicant at this point? Okay, great. Now, are there additional questions from staff at this time? Commissioner Wysong, and I'll just ask maybe Kylie to come down, and we'll see if we need to bring anyone else down, depending upon what the questions are.
Thank you, Kylie. I just want to clarify, since as Commissioner Nelson brought up, we're talking about a very small partial. Another issue was raised about, the Track B being registered versus something else. Does that have any bearing on what we're literally trying to decide today?
So I guess maybe I can get some clarification as far as what you're asking for in regards to Tract B. And I'm just going to pull up another map that maybe be easier. So you were correct in your first statement. We're just looking at this tiny little 350 square feet that would go into the Mariah Trail extension, this cul-de-sac. It wouldn't have any effect on Tract B. Tract B is just reserved for future public right-of-way. So at the time anyone wishes to develop Tract B, it can be developed into county right-of-way.
Okay, thank you.
Okay, so I'm going to take some opportunity to just try and clarify here on the record. a couple of different things. So again, we're here only to consider a waiver and whether that is in the best interest of the county, because we don't typically allow those encumbrances. And as related to the criteria, the only criteria that I think that there could be any question on, which was brought forward by some opposition, is whether it is affecting another property owner. Because this will become a county road at this point, I'm going to make the statement, and if we have someone from Public Works who wants to add this, but we would follow the legal easement access, and this would become a public road. So at that point, even if the property owner made a choice to try to close this off, that would not legally be allowable on a county road.
So I would defer to our county attorney
Okay.
for that.
Or maybe Public Works,
information.
Public Works would not come in and close something. They would continue to leave this access. So in my mind, it actually makes this access more permanent because it's now going to become a county road.
Correct. It would be a county road. There'd be no real reason for the county to close the roadway unless they're doing some repair or anything like that, which would impact any other any other lots that have driveway access, just as we do with any roadway that we maintain currently, where we're doing any paving operations or anything like that. So it'd be that same effect.
Okay, great. And then I will ask our county attorney just to address that. We would continue to follow the access easement and ensure that there was access to that property owner. And do we have any legal concerns that we would not, we would consider that would make this waiver untenable?
Thank you, Madam Chair. To put it succinctly, no, I don't believe that this would create legal concerns. I think that the chair actually explained this correctly in that the purpose of today's hearing is to consider whether or not the county is willing to accept right-of-way with the encumbrance, with the easement that is put in place for access of a property owner. The point of right-of-way, I don't have legal concerns.
Okay, thank you. So with that, I'm going to make sure, do we have any additional questions of staff? Then we will go ahead and close the hearing and bring it up here for discussion and a decision. And I know this is in Commissioner Williams' district. It looks like she wants to kick us off here.
Yes, I just have a few comments. So I do think it is stated by Mr. Whitney best in the Planning Commission discussion that the situation appears to be a personal dispute here between neighbors. And I know this is tough, but my one concern too, that I will stress to the property owner and the developer is that I wrote down that Ms. Donahue does have right to that easement and it cannot be blocked off. I know that easements are controversial. And sometimes you end up with a short-term rental next to you. This is just an example I've had in my past 2 years where a lot of cars are coming across someone's easement. That is a legal access to Ms. Donahue's property. So I just want to ensure that it is not blocked off until other options or Tract B or whatever is developed. But other than that, I find that the requirements have been met and that the dispute is actually not something the commissioner should be dealing with. So my opinion is I'm going to move to approve this unless anyone has any other comments.
So is that a formal motion, Commissioner Williams?
It will be a formal motion. I will move to approve the resolution in the packet that has several different notations, but as it is published in the packet, and I confirmed that the recorded easement that's on county records is recorded correctly on the plat map, and that is how it needs to be. So it looks like they've met all the legal requirements for a waiver.
Okay. Do I have a second for that motion?
Second.
Okay, that has been moved and seconded. One final opportunity for comments, and I see none. We'll call the roll. Commissioner Weissong.
Aye.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams. And the chair votes aye. That passes 5-0. Thank you. I'm going to kind of do a check here with commissioners. Do we need to take a brief recess before we begin the next item? I'm getting a couple of head nods, so we'll take a brief comfort break and be back in about 10 minutes.